If you look at the scope of an arbitration clause, we'll start with the scope. So whenever you have to start the language of your arbitration clause, it is extremely important to cover the range of disputes that you want to be resolved by that arbitration clause. So firstly, we are discussing the range. So range will depend on the language that you're using, the phraseology that you're using. In a lot of arbitration clause, what I have seen is that parties use expressions like dispute arising under this agreement shall be resolved by arbitration. The first line.
Yeah.
Now, the problem is you are restricting the language of the arbitration clause. You are restricting the range of the disputes because you have said that any dispute under this agreement, which means that only if something is relating to this agreement, will be resolved by arbitration. Now, suppose there is a clause, there's a contract in which there are more contracts than one between the same parties, and you would want those disputes also to be resolved by the same arbitrator. At the end of the day, the purpose of arbitration is to be a one-stop adjudication stop, right? You can't really have 10 arbitrations going on between the same parties.
Yes.
If there is any connected matter or a connected disputes, which sometimes may not be under the same agreement, but may be related. You would want that to be resolved by the same arbitrator. Now, the problem is the language that you have used, it will not permit you to let other disputes which are touching upon or connected to the main agreement be referred to the arbitration, because the other side will raise an objection saying that, look, the language says disputes under this agreement can be resolved, nothing else. Therefore, it is always advisable that when you're using the first line, it should be any disputes arising out of or in relation to or in connection to this agreement shall be resolved by arbitration.
Correct.
Now I have expanded the scope of my arbitration clause because there may be disputes which may otherwise not be arising out of this agreement, but may be in connection to this agreement, and they shall also be resolved by the arbitrator. And I'm giving him more power. I'm showing that parties have now agreed that, related disputes can also be referred to the same arbitrator, and we will not have to invoke different proceedings for the same dispute, even if they are not from the same agreement. Now, if we look at the joinder of the parties, so I've covered the accepted disputes that you can actually narrow down the scope of your arbitration in the reference.
Yeah.
But the joinder of parties is concerned. So we have seen a lot of cases like Triun Energy, there is Mitra Guha, ONGC. We have seen Amit Talchan, we have seen Cheran Properties, we have seen Chloro Controls. All these judgments are regarding making a non-signatory a party to the arbitration. So sometimes what happens is that suppose there is a dispute between me and X, and Y is not a party to this agreement. The general law is that anybody who's a signatory to the agreement will only be bound by arbitration. An arbitrator cannot bind third parties because they're not signatory to the arbitration. But in some cases, like I said, when you're using the wide-ranging arbitration clause, scope is wide, then you can actually include the other agreements also. And in exceptional cases, third parties can also be made a party to the arbitration. What you have to show is it can, I think there was a judgment chair in properties wherein it was clarified that, group doctrine, where, companies are same, then probably one of the group company or, shell company can be made a party to the arbitration. Or when the relief is such, which is impossible to be granted in the absence of that third party. These are some circumstances, some commonality of subject matter has to be there to make a third party a party to the arbitration proceedings. Now, if you look at accepted matters, I've told you that suppose that some matters were accepted matters, parties had agreed that this arbitrator cannot look into. And if he does that, then the award will be set aside. For that, you can read judgments like Triun Energy Services versus Indian Oil Petronas. It's OMP Commercial 5 of 2016.